This is Judge Deidre Davis. I have Team Tortfeasors here. The other day, we saw the first team, and today for this first section of the summer, we'll see the second team. That's Team Tortfeasors. And we have our 3L at South Texas College of Law. Talitha Cole will be presenting. Future Attorney Cole, you are welcome to go ahead and begin.
May it please the court?
Yes.
Today I will be presenting on Texas Rule of Civil Procedure 167, which is about offers of settlement and attorney's fees, presented by myself, Talitha, 3L at South Texas College of Law. Assisting me with this presentation is my group, the Tortfeasors. Again, myself, Talitha at 3L at South Texas College of Law, Adam Galani, a 2L at South Texas College of Law, Blake Kistler, a 2L at South Texas College of Law, Genesis Reynolds, a 2L at South Texas College of Law, Joshua Murphy, a 2L at South Texas College of Law, Teresa Iqbal, a 2L at South Texas College of Law, Pavel Bolshakov, a 2L at South Texas College of Law, Lauren Knight, a 2L at University of Houston Law Center, Jeffrey Foley, a 2L at University of Houston Law Center, Jason Law, a graduate of University of Houston, and Alyssa Owens, a senior at Texas Southern University. So typically, the default rule is that in Texas is that every party pays their own attorney's fees, but 167 kind of flips that. Instead, it's a fee shifting mechanism that is designed to penalize a party that rejects a reasonable settlement offer and insists on going to trial, only to do significantly worse than the original offer. And so because the math makes what an offer is significantly less favorable, it can get kind of confusing sometimes. So we'll break it down this afternoon. So generally 167 cannot be used in certain types of lawsuits, in class action suits, shareholder derivative suits, family court cases, workers' compensation claims, and justice of the peace or small claims court. So the first section controls how the process for Rule 167 is triggered and what a valid offer should look like. To bring offers of settlement under this rule, the defendant has to initiate by filing a formal declaration. And then within that declaration, they have to state that the settlement procedure is available in the claim. And the declaration has to be filed at least 45 days before trial. Once the defendant files this declaration, any side, either the plaintiff or the defendant, can make any Rule 167 offers. And there are some strict formal requirements under Rule 167. The offer has to be in writing and be served on all parties. It also has to explicitly state that it's being made under Rule 167 and Chapter 42 of the Texas Civil Practice and Remedies Code. It must identify the exact parties making and receiving the offer. It must state the total terms to settle all monetary claims, and that's including all fees, interest, and costs up to date. And it must provide a deadline for acceptance, which can't be any sooner than 14 days after it's served. The offers may include reasonable conditions as well. So the offeree can object to any condition as long as it's done via written notice. The offer can't include any non-monetary claims like injunctions or anything like that. The offer can't be made within the first 60 days after the party's initial appearance or within 14 days of the trial setting. It also does allow for successive offers, but in order to get those cost shifting penalties under 167, the new offer has to be more favorable than the previous offer. An offer can be withdrawn as long as the withdrawal is requested before the acceptance, and the withdrawal must be made in writing and also served on the offeree. Once the offer is withdrawn, the previous offer can't be accepted or be the basis for awarding litigation costs. To accept an offer, the offeree must serve a written notice of acceptance before the deadline. And if accepted, either party can file the agreement and ask the judge to enforce it. And if an offer is not accepted by the deadline, or if it's explicitly rejected in writing, it's considered rejected and the offer is over. And so for third parties, if there's a third party that's added later on, it cannot be used to, adding the third party can't be used to award litigation costs, but there has to be an objection filed within 15 days of the new filing. So awarding litigation costs under this rule, so this is typically where the penalty is applied once the case goes to final judgment. So if a party rejects an offer and they win a significantly less favorable offer at trial, they must pay the offer's litigation costs. And those costs accumulate from the date of rejection up to final judgment. And for what is considered significantly less favorable depends on whether it's the plaintiff or the defendant rejecting the offer. So if the plaintiff rejects an offer, the defendant wins litigation costs. If the plaintiff's ultimate judgment at trial is less than 80% of what the defendant offered. But if the defendant rejects a plaintiff's offer, the plaintiff wins litigation costs. And if the ultimate judgment is more than 120% of what the plaintiff offered. So what are litigation costs? So it doesn't necessarily count all the litigation costs from day one. It only covers the actual expenses incurred after the date the offer was rejected. So this includes court costs, reasonable deposition costs, fees for up to 2 testifying expert witnesses, and reasonable attorney's fees. The total litigation costs awarded can't exceed the overall amount that the claimant recovers in final judgment. So if a plaintiff goes to trial and walks away with $0, the defendant's cost award is capped at $0. And any award costs awarded to a defendant may only act as a credit or a set off against the plaintiff's recovery. And Texas also has a rule against double recovery. So if a party receives attorney's fees under one law, they can't use this rule to claim those same fees under this rule. And so if there is a party that's penalized with litigation costs, they lose the right to collect fees under any other law for work done after they rejected the offer. And like we said, it must be applied as a set off against the claimant's final judgment. So procedures, so a judge can alter the time limits for filing the declaration or making an offer, but the party filing the motion has to show good cause and the judge signs the order before the trial starts. A penalized party can request discovery to challenge the reasonableness of the fees, but if the court finds that those costs are reasonable, the parties must pay all attorney's fees and expenses caused by the discovery. And then the court must hold a hearing if requested that allows all the affected parties to present evidence regarding the litigation costs. This section deals with the admissibility of evidence, admissibility of the settlement offer during the actual trial. So any evidence regarding the settlement offer is completely inadmissible, but they can be used to enforce an accepted settlement or just calculate the litigation cost awards. And the jury can't know anything about this rule, any settlement offers, or any rejections. So this rule doesn't apply to any offers made during mediation or arbitration. If a rule fails to follow this rule perfectly, if an offer fails to follow this rule perfectly, it can't be used to trigger other litigation cost penalties. And parties still can make, standard settlement offers that don't have to do with this rule at any time without it affecting the case. Thank you so much. And this is our group, the Tortfeasors. And again, myself, Talitha Cole, a 3L at South Texas College of Law. Adam Galani, a 2L at South Texas College of Law. Blake Kistler, a 2L at South Texas College of Law. Genesis Reynolds, a 2L at South Texas College of Law. Joshua Murphy, a 2L at South Texas College of Law. Teresa Iqbal, a 2L at South Texas College of Law. Pavel Bolshakov, a 2L at South Texas College of Law. Warren Knight, a 2L at University of Houston Law Center. Jeffrey Foley, a 2L at University of Houston Law Center. Jason Law, a graduate of the University of Houston, and Alyssa Owens at Texas Southern University. Thank you.
Thank you. Does anyone have any questions? No?
I like the team name we picked out.
I'm sorry?
I like the team name that we went with, Tortfeasors.
Yeah, question. Okay, thank you. If there's no other questions, then we'll go ahead and thank you very much. We will go out and have a wonderful, wonderful rest of the day. We'll stop recording. This is Judge Deidre Davis, presiding over 275 District Court and summer law club, the second section, and